Okay, if you qualify, you meet the minimum requirement, the employer in terms of the prerogative, they decide to shortlist you, you go and contest the position, and if you are not appointed and you feel that maybe it's because of unfair discrimination, the Employment Equity Act in terms of Section 9 defines an applicant as an employee for purposes of making sure that we break these barriers of discrimination. Then by all means you'll have a right as an applicant to refer a matter to the CCMA, wherein you will be arguing, for example, I believe I've been discriminated on any listed ground or any arbitrary ground. Listed grounds are there. Section 6 of the EEA 6.1 talks about those listed grounds,
It's interesting that you mentioned, the ability for the potential employee to appeal a rejection, right?
Yeah.
And you're saying, for example, they could say, look, I believe that I've been discriminated according to these listed factors.
Yeah.
Wouldn't that require that employee to have access to certain information that pertains to the hiring process of their company, which is basically all the other applicants?
Okay, if you allege discrimination on listed grounds, the onus is on the employer to prove that there is a discrimination, it was fair, it was rational, it was justified. If they cannot do that, then the inquiry ends on listed ground. But if you allege discrimination on arbitrary ground or on any ground, simply put, that is outside the 19 listed ground, now the onus is on you to prove that on what basis or what grounds were this. Then the employer will have the reverse onus of proving the existence or non-existence of that discrimination after you have tabled it. However, even if in Section 6.1, even if the onus is on the employer, obviously you'll be expected to just give a brief story without necessarily discharging the onus, because at the end it will be the employer who must discharge the onus or confirm or the existence or non-existence of that discrimination. If it's there, the employer can say it's in terms of affirmative action, in terms of the inherent requirement of a job, or in terms of any justifiable ground, in terms as per a jurisprudence or case law.
In your experience, how practical, and by practical here I mean sort of easy, right? Is it for the employee to put forward a case of discrimination outside of the listed? I mean, even within the listed discrimination factors, when you consider that this lack of access to that information, for example, can the employee request a list of applicants?
Look, every case will speak for itself. It depends, If, for example, you lodge a grievance and following that interview, you are not successful, you start internally first, the employer, I believe I was also the suitable or if not the best candidate. But remember, as commissioners, it's not our duty to appoint or to decide. Our duty is to test the fairness of the decision, whether it was fair or not in our view, whether we believe that they should have taken candidate number one or number two.
Yes.
No, that's not. The test is the rationale behind the employer making that decision. Is it fair to have made that decision? All factors considered. Sometimes even if I'm a candidate for affirmative action, the employer can say, look, there are other factors, justifiable reasons that I was looking into. For example, your experience, your qualification.
Or the fact that you might live out of town.
Exactly. You may be a female, you may not be paid equally with this person because, of certain things.
Off, you've got it, or whatever, so on and so forth, that are specific to that case.
Exactly. Then on those bases, we maybe say, look, even if you are a candidate for affirmative action, in terms of the inherent requirement of a job, and in terms of justifiable grounds, this is how the employer made their decision. At times, even if you are the best candidate, the employer may not take you as the best candidate, and they may have justifiable. Maybe they say age. We're looking at the age because we want to invest. Would rather take a young person based on their potential to acquire, those skills and knowledge. Where you have the experience and the knowledge, but you are at that advanced age, it may not be advisable for you to take you under these conditions because you want longevity.
Yeah.
Those are the factors.
Understanding the role of the CCMA.
Yeah.
I would say that the CCMA's role is heavily dependent on the cooperation of the parties, right? So, especially when you speak about the conciliation stage, wouldn't you say? If we move on to the arbitration stage, how many teeth does the CCMA have in requesting certain cooperation during the arbitration phase? So, for example, is the employer or the employee obligated to provide certain information the CCMA would need to arrive at an arbitration decision?
Yeah, look, if there's certain information that will ensure that there will be, in the interest of justice, we require these documents, they're relevant, they have material impact on the outcome of that process. By all means, the commissioner has got those powers to order the employer to produce those documents or to cooperate or a witness to come and testify. However, at times the commission may not see the relevance or the material impact, and they may decide, but we don't decide before. We have to listen to facts, and then we have to look at the dispute and say, in the absence of this document or that information, we won't be able to arrive at a fair determination. Yes.
So when you say they do have the powers, if the employee or the employer do not provide you with the information, what can you do to enforce?
Remember, the commissioner makes an order that the following documents are required. And then if you don't cooperate, you are found in contempt of the CCMA. And the CCMA can make your findings and refer all those records to the Labour Court.
To the Labour Court?
Yes, and the Labour Court can make an adverse findings against yourselves.
So should the CCMA refer the matter to the Labour Court for the reason that we just discussed here?
Yeah.
The Labour Court process then begins there, right? They don't just pick up to say, they don't just take your word for it. They begin the Labour Court process in terms of hearing all the facts and going through everything else to...
Yeah, remember we take the records for contempt to them.
Yeah.
And then how they handle it, obviously they'll have to hear your side of the story as a person who is alleged to have acted, in an acceptable manner in the proceedings, or who has refused to cooperate or even to take an oath or to come and testify, or who have even preempted the outcome of the process. So if your conduct is unacceptable and the commissioner so decide, they'll do so. But most of the time, the commissioner will alert you to the potential danger that you might get into if you don't cooperate.
What is the difference between a labor court case and a civil court case?
A labor court case, it has to do with labor matters. A civil court can even include criminal proceedings or...
Civil court because the way I understood it, a criminal case is different to a civil matter, isn't it?
That's the overarching terminology. You say it's a civil proceedings. If they want to take it to the labor court, to the criminal court, they can do so. But if they want to take it, we'll define what we mean by that.
Yeah, correct me if I'm wrong here. From what I understood, a civil court case has a lower threshold of proof, isn't it? Like a criminal court case has a proof beyond the shadow of a doubt.
Okay, we normally say we make our decision on a balance of probabilities, which is a lower standard of proof than when you have to go to the courts, which prove beyond reasonable doubt.
When
Like,
you
for
say the
example,
courts, you mean the
courts, various courts. Remember, we are a tribunal,
Yeah.
and other courts, they are courts, they've got more muscle than us,
What I'm trying to get at here is I'm trying to understand the differences. If this matter goes to a labor court, how serious is the matter relative to other types of cases? Because I'm trying to determine just the legality, the power of the law behind such a case. Would you say it is fair to say a labor court is a civil court that only deals with labors of labor.
Yes, it is fair.
It's fair to say.
Yeah. But it doesn't mean we don't have a legal force, because we derive our powers from legislation, obvious. That is why if you fail to comply or cooperate, there will be consequences.
There will be consequences.
Yeah.
Understood. The CCMA is there to represent both interests. It doesn't choose a side, right? It's looking for social justice.
Yeah.
It's funny that I mentioned social justice. I just remember.
I could. Yeah, you were correct. Absolutely, because it's there in employment relations. You know, and I remember when I take an oath of office, I take an oath to execute my powers without any fear or favor, in line with the purpose, the object, and the spirit of the Constitution of the Republic of South Africa. So in exercising that power, I am cognizant of the fact that I need to be fair at all material times. Exercise that without fear or favor.
So you mentioned that the democratization of the workplace, one of the examples you mentioned was the employees, let's say, right to contribute to social justice in the workplace. So social justice is basically, you're talking about fairness, treating people as human beings and respecting their rights in the workplace.
Yeah.
In what ways would you say the employee in the workplace can promote social justice? What power do they have in the workplace? And just to finish my question, is that power basically an example to call the CCMA? Is that the only way that we're talking about promoting social justice, or the power of the employee to promote social justice?
All right. CCMA become one of the ways, but the first thing that we normally promote, we say these things should be dealt with internally, where the employer is afforded an opportunity to deal with this. For example, if there are any other dispute, whether it's bargaining or matters of mutual interest, the employees need salary adjustment or to better their conditions, you can't just run straight to the CC. You need to afford, it's a process, you need to afford the employer an opportunity to listen, and maybe you can be able to resolve the issue. If that fails, is then you are looking at the next forum, saying, let's go to the CCMA. If there are issues of discrimination, harassment, the employer may not be aware at that time. So it makes sense to afford the employer an opportunity to deal with that. And if the employer trivializes or is ignorant, is untransformed, then you can say, look, I had no choice here but to go to the CCMA. But at times, depending on the size of the employer, you have your corner shop where the owner is the HR, is everything. I mean, logic will dictate that you can't refer the matter to the same person who is the subject of the dispute and appear before them, because that would be unfair. Under those circumstances, you can explain to say, no, there was no need, because to me is the same person, is the employer, is the HR, is the director, is everything. So how do I refer the matter to him or her? That won't be in the interest of justice, will not be served.
Okay.
Then you can go outside.
So one thing I'd like to check with you.
Yeah.
Actually, we'll return back to this preference that the matter be dealt with internally first.
Yeah.
I would like to touch with you on the nature of the employment relationship. Correct me if I'm wrong, but I remember reading in the Code of Good Practice that the LRA does acknowledge that the employment relationship is unequal.
Yeah.
And that the LRA serves to equalize it. So in what way would you say that the employment relationship is unequal?
Look, the employment relationship is unequal because who has the economic power? The employer. Who has decision-making power? The employer. Now, in order for that to be balanced, now at times employees would belong to a union, which unions will, in essence, is an effort to try and balance the power relations. Or employees will themselves, as a collective, belong to a workplace forum where they can bargain and negotiate and seek, assistance from the employer. Alternatively, if everything else fails, employees will now resort to a forum like the CCMA, where they can, express their wishes and seek some form of relief. In the absence of that, having no forums like this and the employee not having the powers to act as a collective, that means it gives the employer a license to do as they please, because there won't be any check and balances. So that is where we say that relationship is unequal. Internally as an employer, you've got the powers to make decisions whether they're fair or not. You've got the power to hire and fire. In the absence of any check balances, then you'll do it like in the past, where employees could be hired and to be dismissed at the drop of that without any recourse.
So given that the employer has economic power and decision-making power over and above that of the employee, how do you think that affects the internal resolution of a problem between them if they're already unequal? The employer has a power advantage in that discussion to resolve the problem. Do you see that there is I don't know if conflict of interest is the right word?
Look, when we talk about that imbalance in power, we are generalizing. There are employers who are very progressive, transformed, and they do listen.
The second section of the interview started off just carrying on our discussion on the CCMA's role, mainly in tackling issues around discrimination and harassment. Again, as I said in my last commentary, that although these issues are important and they may even overlap or touch upon the employment relationship, I wasn't specifically focusing on them. I'm mainly looking at what the employee can do to better represent his or her own value within the employment relationship. What is it that can equalize the imbalance between the employee and the employer? We basically started off discussing certain protections that the employee has should he or she complain about the conduct of the employer, mainly with regards, again, to listed grounds of discrimination, right? The example that Mr. Peko Molefe gave was with respect to applying for a job and not being selected. So again, I let that play out, but it wasn't really the crux of what I wanted to get to. One thing I did do, though, to try and take advantage of that topic was to understand the employee's power in that process, right? If an employee does call upon the CCMA to complain about the conduct of the employer, especially in this case as it refers to a job application, meaning issues of discrimination, what powers does the employee have to more effectively put across their case, right? Can I, as an employee, request the information I need to verify my complaint or to know that I do actually have a case? And it doesn't seem to be the case, judging from the answers that I got from Mr. Molefe, right? The employee simply complains and alleges discrimination without having access to the information, access to the behind the scenes of the recruitment process. Can they go to the HR department of the employer and request a list of applicants and request information pertaining to decision making by way of dealing with this sort of supposed disagreement internally before the CCMA is ever called? And I would posit to you that the employee doesn't have that power, and in fact, the employer wouldn't cooperate. They wouldn't want to provide the employees said information. And I think there's grounds for that. They could argue that by providing this specific employee who's complaining access to this information might somehow be disadvantaging the other applicants for that position. Maybe. I mean, I would certainly argue that. So, I just feel like, again, being able to complain to the CCMA about discrimination is good and it's important, but it doesn't deal with it. I feel like it dabbles more in issues of equity, meaning differences amongst employees relative to how well they're treated the same, rather than actually dealing with the relationship between the employer and the employee and the power difference between the two. I think this is somehow overlooked. One of the other issues that we moved on to speak about was when I questioned Mr. Molefe on the seriousness of civil cases relative to other types of cases, such as criminal cases. And I didn't really explain it. He understood what I wanted to get to, but I feel like I didn't express it properly. Essentially, and I did end up looking into this after the interview. But essentially what I was getting at is, how serious are these matters, right? What is at stake for he or she that refuses to cooperate? What is the end punishment, should you want to put it that way? So, civil matters have a law of burden of proof, as we discussed in the interview. There we're talking about the balance of probabilities, which is considered a lower burden of proof than proof beyond all reasonable doubt. So in that way, then it's considered, I would argue, legally that it's less serious of a matter than a criminal matter. The differences that I recently learned when I looked into this is that, well, a criminal case is mainly a case where there's a disagreement between the accused and the state, right? So the country, the government, let's say. So the government has a problem with the individual that broke the law, right? Meaning the individual caused the government a loss by breaking that law. So the government is essentially taking that individual to court in order to get remediation, to get something back for it. And the end goal is to imprison the person. So imprisoning this person is somehow a way of paying back the government for the loss it incurred when that law was broken by that individual. Okay, so this is this is sort of the gist, my understanding of criminals. Where civil matters are matters of disagreement between citizens or between two other individuals. They don't include the government. No, I don't want to, go that far. I'm not a legal expert, but no specific law was broken. It's more that one individual is not happy with the outcome of an agreement or with the outcome of the actions of another individual, and therefore now they are claiming remedial action to compensate them for whatever loss they perceive to have lost. It's not necessarily that this person broke the law, it's just that this person made the other person unhappy. So ask yourself this question: how serious is a matter of exploitation? How serious is a matter of essentially paying someone slave wages or treating them like a slave? Right. Essentially, this is the point of the Golden Egg series. Is that, are you a slave? As a citizen of a democracy, are you a slave? And I feel that employees are not slaves. They are citizens of a democracy. And therefore, they should be able to represent their value whenever they establish an employment relationship with an employer. The employee should be considered an equal with the employer. Why is the employee not an equal? Anyway, this is the point that I was getting at. So the less seriousness of the matter, and I'm not necessarily arguing that it should be a crime as other crimes. I'm not a legal expert, I said. But I'm bringing it to your attention to say, if treating employees as slaves is considered a civil matter, right, in the way that you pay them, but also in the in the manner in which you structure the relationships with them. The fact that employees most often times don't have a say in the drafting of their own employment contracts. They receive an already written employment contract and they just have to sign. There is no discussion. All right. So the question that comes to mind is, okay, so he does actually mention Mr. Peko Molefe he does mention in the interview that compensation is the outcome of these cases. So what happens if, my understanding of what happens if the employer refuses to pay in a case of harassment or unfair dismissal or discrimination or so on, I would imagine that it would be processed very similarly to someone refusing to pay back a loan. Their property can be seized to be auctioned and then, so that those proceeds can be used to pay off whatever amount is owed. That's what I would assume. But again, for those who know, kindly comment accordingly. I don't really want to go down that route, but essentially, this is why I brought this into, to your attention, to say if it's less serious, what does that actually say? And this is the question: if the matter is less serious than a crime, then what does it say about the importance of the rights of the employee in the employment contract? So exactly how much power and what power does an employee have when in representing his or her side in dealing with a problem he or she has with the employer? This matter is supposed to be handled internally first. So, and I did ask this in this section, that given the power imbalance between the employer and the employee, really how much problem solving can happen there genuinely, where the employer does not use or utilize their power differential to leverage an outcome they desire in discussing this issue or trying to resolve this problem with the employee. I mean, what are the chances that the resolution of this problem advantages the employer more than the employee, or is even done in a way that is fair according to the CCMA, meaning according to the law or the state, but unfair as it applies to the employee? And the reason why I say this, I mean, if you look at the current employment relationship, it is all fair. I mean, the employment relationship is legally acknowledged to be unequal, and we do actually mention this in this section. It is legally seen as unequal. Now, the law is supposed to equalize that, meaning the law is actually supposed to benefit the employee more than the employer, because that's how you equalize it. You give more to the employee so the employee can be propped up to the level of the employer. But this is not actually what happens. If you listen to the first section, where the CCMA comes in, where the state comes in, where employment legislation comes in, is when the internal resolution of the problem has not worked. Right? They only come in then. And when they come in, they're only interested in what? In the employer's compliance to the law. That's all they care about. They're not representing the employer, and they're not representing the employee. So therefore, the employee is not getting propped up in any way. They're both being treated as equals, but they're not equals, as the law itself states. So another question mark there. That is not the answer to the question, what can the employee do? This is not what the employee can do to take back his or her own power in engaging with the employer in the employment relationship. So towards the end of my second section or second section of my interview with Commissioner Peko Molefe, we were busy discussing the power that the employee has, especially in the case of a dispute with the employer. What power does the employee have to more effectively represent him or herself in that situation? And essentially, Mr. Peku referred to the fact that some employers are more fair and they're more willing to cooperate with employees in such cases. They're more willing to listen and they're more willing to be fair in their decision making, how they handle the dispute. All right. Now, he used the words they're more transformed and more progressive. Now, from what I understand, and this is just from basic understanding, I haven't really delved deep into this, but my understanding of transformation is it has more to do with issues of discrimination. So being more inclusive of people from different backgrounds, people of different nationalities, ethnicities, backgrounds, and treating them the same in accordance to the standard of the company or the culture, the corporate culture. So that's my understanding of transformation. And my understanding of being progressive is in line with my understanding of employee engagement, right? Being progressive has more to do with making the employee feel like they matter, feel like what they have to say has an impact on the decision making the employer then undertakes, right? That the employee has a role to play in the employment relationship. But I think, like employment engagement, the key is the employee is made to feel that way, right? The power structure is still the same, which is unequal. The employer is the one that ensures and facilitates for the employee an environment that makes them feel equal when they're not, right? And for me, therefore, the issue of being progressive has the same criticism that I have for employee engagement. If you read my article, "The Golden Egg: A Worker's Resolve," the employee is supposed to take back his or her own power to represent and to gain the satisfaction or to negotiate for his or her satisfaction when establishing the employment relationship. Not to have their satisfaction depend on the goodwill, progressiveness, or transformation of the employer. You see? And like employee engagement research, which facilitates, which focuses on the employer facilitating a certain environment that makes the employee feel a certain way, to encourage them to garner a certain level of loyalty to the business. When in actual fact, the employee ultimately doesn't actually benefit. Ultimately not. In the long run, not. In the short term, yes, while they're still employed with the employer. But once they leave, the benefits that they get, right, from the employment relationship with respect to the facilities that are given to them while they work at the business premises, they're tied to that employment relationship. They leave those behind. What do they take with them? What do they take with them? Right? And this is where this is my issue with sort of the state depending on the employer to facilitate satisfaction for the employee. The employee can and should facilitate their own satisfaction. And that's why the job interview is meant to be a negotiation. It's meant to be a negotiation. The employee is supposed to have enough power to counter and to reasonably, in good faith, right, argue for a better deal. Not depend on the employer for that. One example that comes to mind is, it's as if the employer is a farmer and the employee is one of his stock. So the farmer has an immense amount of experience farm herding and farming stock and animals, right? Or animals. He knows all about them, or she knows, he or she, and he's been studying them. So he knows all these things about them, but he or she then makes the decision on how to keep them and how to feed them and the conditions of their existence so that they can grow and net him or her greater profits and so on and so forth. They don't have a say in that. They don't actually have a say. They're just objects of research. And this is my problem. Employees are not animals. Right? Employees are not children. They're not employers' children. They are adults, people, who have their own agendas. So this has to be acknowledged and it has to be respected. This is what is missing in the employment relationship.